Welcome to episode 187 of AAA Weekly Webinar Series. Today, we have carved out a subject for you, which is exclusively handling the Section 7 application under Insolvency and Bankruptcy Code. Now, Section 7 application can be filed by any financial creditor, either individually or jointly, in case there is a default, and then in case the application is admitted, then the company will be declared as insolvent and the corporate insolvency resolution process will be started. Even Section 7 applications can be filed jointly by allottees of real estate, or we can even call home buyers of any real estate project. For the last 7 to 8 years, there has been too many judicial pronouncements about applications which are admitted by NCLT and applications not admitted by NCLT, dismissed by NCLT, rejected by NCLT. So today we will actually bring before all of you all those reasons where the application can be rejected by NCLT and the insolvency resolution process of that company would not start, even if the application is filed by a financial creditor. So Ankit, let us try to understand first of all, what are the basic conditions for filing the application under Section 7 of IBC?
So before we go to that, I believe it is very important to say that timely admittance of Section 7 applications is one of the key milestones that the ecosystem of IBC requires. It is a common complaint of many financial creditors, which includes banks, that the Section 7 applications are not being admitted in time. The stipulated time, of course, in the IBC is 14 days, when then another 7 days which are permitted to appoint the RP. But this timeline, of course, is something that the IBC amendment bill also works on, and I believe we will also discuss that part in this series.
So the Section 7 application can be filed by a financial creditor. As I said, it can be filed by a home buyer, it can be filed by an allottee, it can also be filed by an assignee or transferee of a debt. Now, there are other conditions which are actually applicable as a threshold limit for filing a Section 7 application. So that is, first of all, there has to be a default. First of all, there has to be a debt, and that should be a financial debt, and the creditor should be a financial creditor. And then there is a condition that the debt should be minimum of rupees 1 crore. If the debt is not 1 crore, then the Section 7 is not applicable and no application can be filed before NCLT for initiating corporate insolvency resolution process of the company. Now, even for the real estate cases, there is a threshold limit that either 10% of total allottees of that project or 100, whichever is lower. Now, for example, if the total allottee or total home buyer who have booked a unit in a real estate project are say 500, then 10% of this 500 would be 50, or in case the total allottee are say 1800, then the 10% will become 180, but minimum is 100. So therefore, minimum, whatever is minimum, so in case of 500, 50 would be the minimum requirement, and in case of 1800, 100 home buyer will have to collectively file an application. That is a minimum threshold for filing an application under Section 7 for starting a insolvency resolution process of a real estate company, that at least 10% or 100, whichever is less, should be the total number of allottees who can file this application jointly.
Crore is supposed to be with interest.
For the real estate cases, it is not with interest, because for real estate cases, this interest is only for the purpose of voting share and is not considered as debt. However, for other financial creditors, this 1 crore figure is with interest. And that with interest means whatever interest rate is mentioned in the documents, that is the interest rate. In case with interest, if the amount becomes more than 1 crore, it is definitely a case where the minimum threshold is achieved. However, in the case of allottees, in the case of home buyers, this has to be the original amount paid. The interest, which is 8%, that is only and only for the purpose of voting share, not to be considered as debt.
Also, in terms of if some financial creditor does not have a 1 crore debt, he can team up with other financial creditors and have a joint application and file an application if the total debt exceeds 1 crore.
Absolutely. Ankit, this is a very important question that you have said. Operational creditors cannot file a joint application, because in operational creditors there is a concept of dispute. So there may be a case that with one operational creditor there is a dispute, for with the another there is no dispute, so therefore they cannot file a joint application. However, the financial creditors can file a joint application. Now, I know a case where the employees of the company, when the company in fact launched a scheme where the employees have in fact given loan to the company at an interest rate. So a few employees came to us and they wanted that, can we file an application against the company? And we said yes, because they had given loan for 4 years back. It could not have actually been considered as connivance. There was a default. There was repayment also, which was being earlier repayment also by check by the company. So there was a complete evidence that this, yes, the company raised loans from the employees and then the company repaid. There was an agreement, there was an interest payment, and later on there was a default. So it was a good case, and NCLT admitted that case as under section 7 jointly application was moved by the employees of the company. Similarly, any other persons like debenture holders, they can also collectively come, jointly can come, and they can file an application even if the individual debenture holder is not having an outstanding of 1 crore. Basic conditions: there should be a debt, and that should be a financial debt, and the applicant should be a financial creditor. Second condition: there should be a default. There should be a default, and that is also proved. Yes, there is a default, and then the application should be complete in all respects, as per all forms, and all kind of documents are attached. And in case the documents are not attached, in case there is any deficiency, then section 7 subsection 5 puts a responsibility on NCLT that the 7 days period will be given for curating the default. So that would be given, and in case it is curated within 7 days, then that deficiency can be curated. Then the other important part is limitation. Debt should not be barred by limitation. So these are primary conditions under which the application would be admitted. The role of the adjudicating authority, first of all, is to see whether there is a debt, and that debt should actually be a financial debt, so that the application under section 7 is possible. Then there has to be a default, and then the application should be complete, otherwise there will be a deficiency. And then finally, the application should not be barred by limitation. In some of the opinions, it is also said that the IRP which is proposed in the application should actually have a valid AFA. AFA is not valid, then NCLT will give an opportunity to the applicant to give another name, or NCLT can admit the application by appointing somebody else from the panel, or taking some recommendation from the IBBI as per law.
So from my experience, I have seen that in case the latest AFA is not on record with the NCLT will normally say that, okay, you submit the latest AFA of this RP, because at times the time that NCLT takes in admitting Section 7 applications is on the higher side. So the AFA that is attached along with the application might have expired. So this is what I see, that this permission or this requirement is then stated by NCLT when they are about to admit the CRP.
Yes, Ankit. I think this is very clear that one opportunity for curating the defect must be given. And if the applicant is not able to curate the defect within 7 days, then NCLT can do what it deems fit. Maybe one possibility that the 7 days can be extended, and the other possibility is reject the application with the liberty to file again. So that's what normally happens in NCLT. So we have to be very, very careful about all documents which are required are attached. So therefore, all the evidences of debt, all the evidences of default, and also there is no barring by on limitation. Ankit, when this condition was inserted in the code that for any application from home buyers or allottees, there has to be a 10% or 100 minimum threshold. That particular insertion in the code was upheld by Honorable Supreme Court in the case of Manish Kumar versus Union of India, and that was done in 2020. And because the Supreme Court said that it is a filter against frivolous or speculative filing by investors while preserving the genuine creditor's remedy. That was held by Honorable Supreme Court. And however, very recently, in September 2025, the Supreme Court has held in the case of Mansi Brar versus Shubha Sharma that the speculative home buyers are barred from filing Section 7 application, and there is a detailed definition of speculative home buyers or speculative allottees, and there are 7 checks that the NCLT can do to find out whether the applicants are speculative or they are genuine allottees or home buyers. Cases where the NCLT has rejected the Section 7 application.
I think it's also about authorization. So proper authorization is something that NCLTs have held should be there. So the banks or companies which are acting as financial creditors, they should typically authorize, or they typically authorize via board resolution or a power of attorney. So in the case of Tech Travels Private Limited versus Altius Travels Private Limited, NCLAT had held that an authorization letter issued even before IBC's enactment could be valid for filing an application. So the key is that the person suing on behalf of the creditor must be duly empowered. So of course, these are procedural matters which are nitpicked by the opposing counsel whenever such a matter is before NCLT or NCLAT. But yes, one can be careful and ensure that the authorization that they have from the creditor is in order, and it is not something which can be used to delay the application or oppose the application.
See, the complete and correct documentation is also a requirement. So it includes the proper dates of disbursement of debt along with all the documents to show that it is debt. Then it should also have a proper information and documentation of default. And then also it requires the application is complete. So in one case, in fact, that case that it is important that I should highlight that case in the case of HDFC Bank versus Livin Aqua Solutions Private Limited, and this is the latest judgment dated 27th of August 2025, where the NCLAT, in fact, that particular application was rejected by NCLT only because of some deficiency in the document. However, NCLAT held on 27th of August 2025 and criticized NCLT for dismissing a Section 7 application due to a defective affidavit without allowing cure, reiterating that procedural lapses should not defeat substantive rights. Now, similarly, the one amendment in the information utility regulations, it was notified that the record of default as certified by information utility is mandatory to submit. In the case of, in fact, NCL 80, in the case of Vijay Kumar Sanghania versus Bank of Baroda, on 13th of December 2023, held that since there is no amendment in section 7, subsection 5, where the list of documents is given and there is no amendment which provides for record of default to be taken from IU, therefore the application cannot be rejected only because record of default is not submitted as provided by information utility. And even the Supreme Court also upheld that judgment of NCL 80. Because of this Supreme Court judgment, the amendment bill has now provided an insertion, a kind of one explanation 2 has been added in section 7, subsection 5, where it is now proposed that if the record of default is obtained from IU and is submitted along with the application under section 7, then that would be the conclusive evidence of default. So that would be accepted by the NCLT. So this is one on various documents. So Ankit, like, what are the other grounds where the section 7 applications are getting rejected?
So, one, there is a possibility that the NCLT determines that there is no financial debt or no default. So, a Section 7 petition is liable to be dismissed if the claim does not qualify as a financial debt under Section 5(8) of the IBC, or no default has occurred in respect of such debt. So, as per Section 5(8) of the Code, a financial debt must involve a debt along with interest, if any, which is disbursed against the consideration for the time value of money. So courts have consistently rejected petitions where the transaction is a disguised equity instrument or a disguised share instrument. There is no disbursement against the time value of money. So wherever they find that there is no disbursement against time value of money, there they have rejected petitions. Then it is where the debt is disputed or merely internal book entries lacking enforceability. So some of the key judicial precedences here are one in MS Santoshi Finley's Private Limited versus State Bank of India, which is an NCLAT matter. The NCLAT upheld the dismissal of a Section 7 petition where the alleged loan of 92 lakhs was found to be an internal arrangement between group entities controlled by the Mittal family. It lacked the characteristics of a genuine financial debt and was treated as an equity infusion to regain control of the corporate debtor. So the petition was also found to be fraudulent under Section 65 of the IBC, and a 10 lakh penalty was also imposed. In Mansi Brar Fernandez versus Shubha Sharma, we just talked about this matter. This is a very recent judgment. The Supreme Court dismissed petitions of home buyers who had entered into agreements with buyback clauses and assured returns. Now, if an agreement has buyback clauses and assured returns, one can say that these are investment vehicles, and it is only it is only on paper that they are seemingly investing in as a home buyer, but they are looking at assured returns and they're looking at returns, and they're not genuine home buyers, or they're speculative home buyers. In a very recent judgment called EPC Constructions India through the Liquidator versus Matix Fertilizers and Chemicals Limited, which is again a 2025 judgment, the Honorable Supreme Court considered whether the holder of cumulative redeemable preference shares could be treated as a financial creditor under Section 5(7) and 5(8) of IBC, thereby entitled to initiate CRP proceedings under Section 7 of the IBC on the ground of non-redemption of such shares. So here again, the financial statements, whenever such redeemable preference shares are issued today under Ind AS can allow such redeemable preference shares to be classified as a debt where these convertible or sometimes convertible preference shares are not in the money, or wherever they are not convertible at all, they are not convertible, even then they are treated as debt instrument in the balance sheets of companies where Ind AS has been adopted. And there again, the court held that preference shareholders are investors and not creditors, as preference share capital forms part of the share capital and not debt capital of a company. The amount paid up on such shares is not a loan, and dividend or redemption can only occur out of profits or fresh share issue proceeds under Section 55 of the Companies Act 2013. So they dismissed and said that the commercial effect of borrowing is missing in such CCPS issues. Now we have seen some structuring, and we have also seen that there is a concept of convertible debentures now, which is used for the purpose of investment by investors into the startup entities. So we will see how the law evolves on that as well. But for preference shares, Supreme Court in this judgment has very effectively concluded that no, this is investment, this is not a loan. We cannot say that this is a financial debt.
We can also talk about some judgments where the minimum threshold has actually been considered as mandatory. And in the case of real estate cases, where the minimum threshold of number of applicants or number of allottees has also been upheld as mandatory. So this actually the petition, NCLT have consistently been rejecting such petitions, and I will just say that couple of these judgments that we would like to highlight only as a concept, that the minimum threshold of 1 crore and the minimum threshold of 10% or 100 allottee, that is mandatory. See, I think we can actually refer to this Madhusudan Tantia versus Amit Choraria, and that's in NCL80. In fact, NCL80 dismissed the appeal against NCLT's order, which has rejected a Section 7 application for failure to meet 1 crore threshold. The tribunal held that the default amount must be rupees 1 crore or more on the date of filing of the petition, and any default below that is non-maintainable. The legislative intent behind increasing the threshold was to prevent misuse of the code. For small claims, even where the default amount was marginally lower than rupees 1 crore, the tribunal found the bar to be absolute and jurisdictional in nature. So there is no kind of power with the and with the adjudicating authority to tweak this minimum threshold limit. In the case of Pawan Dubey and others versus Pawan Dubey versus JBK Developers Private Limited, in 2018, NCL80 upheld a dismissal of Section 7 petition filed by a group of home buyers. The petitioners failed to constitute 10% of the total allottee in the project, and some of them were from a different real estate project altogether. So what they did, they in fact two different projects, and they in fact combined together. So then they filed this application. So NCLT, now of course there is a complete view which is in the market that for insolvency cases it has to be a project-wise insolvency, and therefore it should be a project-wise application also. So the tribunal held that numerical requirement under second proviso to Section 7 subsection 1 is mandatory, and its non-fulfillment renders the application not maintainable, and the NCLT is not vested with the jurisdiction to entertain such petitions unless the statutory class threshold is met, because this is called class threshold. Class threshold is applicable to allottees. So therefore, in case this class threshold is not met, the NCLT does not have any jurisdiction to admit. So Ankit, there is a lot on Limitation Act, and in the Limitation Act, one that the first time, in fact, the Supreme Court said that yes, the Limitation Act is applicable to IBC. It is applicable to IBC claims also. So therefore, Section 7 petition is liable to be dismissed if the outstanding amount is barred by limitation. Now there is a different subject, that there is an extension of limitation period because of some acknowledgement, because of some part payment. So we can actually refer to various judgments which are on limitation. So the key principles on the limitation, which actually we can say, of course, all this that we are saying is backed by some of the Supreme Court judgments. One, that the balance sheet entries. One, the balance sheet entries or settlement offers or even restructuring proposals may constitute valid acknowledgement. Second, if no acknowledgement exists, the petition is time barred even if the debt remains unpaid. In the case of BK Educational Services Private Limited versus Prag Gupta, the Honorable Supreme Court on 11th of October 2018 held that Limitation Act applies to IBC proceedings from its inception. The limitation period for filing Section 7 petitions is 3 years from the date of default, and tribunals cannot admit time-barred petitions. In Gaurav Hargobind Bhai Dave versus Asset Reconstruction Company India Limited, which is ARCEL, in 2019, the Supreme Court dismissed a Section 7, a petition filed in 2017 for a default that occurred in 2011. Due to absence of acknowledgement, the limitation was applied strictly from the date of default, and in this particular case, no acknowledgement was found, either by way of balance sheet entries or by way of any repayment, part payment, or by way of any settlement application, or by way of any kind of restructuring application. So nothing was found. The debt was in 2000, default was in 2011. Limitation period will actually start from the date of default and not from the date of debt. In another case, which is in Asset Reconstruction Company India Limited versus Bishal Jaiswal, on 15th April 2021, Honorable Supreme Court in fact held that signed balance sheet entries can amount to acknowledgement of debt under Section 18 of the Limitation Act, thereby extending the limitation period for filing Section 7 petition, and it overruled NCL 80 full bench decision in the case of V. Padma Kumar versus Stressed Asset Stabilization Fund, where the NCL 80 had held that entries in balance sheet being statutory filings could not be treated as voluntary acknowledgement of debt. The Supreme Court clarified that what matters is whether the entries indicate a subsisting liability, and that such acknowledgement, even without express admission, can revive limitation under Section 18. In another case, which is in Dena Bank, now Bank of Baroda, versus C. Shivaraman Reddy, the Supreme Court on 4th August 2021 held that repeated acknowledgement of debt by the corporate debtor through settlement proposals and entries in balance sheets extended the limitation. Although loan had turned NPA in 2008, the application filed in 2018 was held maintainable due to such acknowledgements.
We can now come to defaults that are covered by Section 10A of IBC. 10A of IBC is another innovation, that's something that came up when the COVID pandemic came in. So from 25th of March 2020 till 24th of March 2021, this full 1 year, a period was charted out that if a default has occurred during this period, it will be deemed that the default has occurred due to COVID pandemic, and therefore insolvency with respect to such a default cannot be initiated. So this is how this 10A came into picture. I still remember that day when we heard we heard the chairman of IBBI at that point in time talking about why this provision has been come in, and he said that in absence of white knights to save these companies when everyone is having trouble, then how can you save, who will save these companies? So in case there are no saviors, then there is no point in initiating CRP against these companies which is defaulted because of a pandemic. So, how has this problem or this issue? Now, today one can say that this period is already over. If somebody had defaulted during that period and nothing has been done with respect to that, debt has not been renewed. So, what to do with these matters? So, the point is that if somebody had defaulted at that time, how do we deal with those defaults in case they are still in default today? That is what we are trying to address here. Key judicial precedences here are a case called Ramesh Kaimal versus Siemens Gamesa Renewable Power Private Limited, which was in wherein the Supreme Court had dismissed a Section 9 petition for a default dated April 30th, 2020, holding that Section 10A clearly prohibits initiation of CRP for the default during pandemic window. The court held that the bar applies retrospectively even to petitions filed after the insertion of Section 10A. Then the next case that is important here is IDBI Trusteeship Services Limited versus Direct Media Distribution Ventures Private Limited. Here, the NCLAT upheld NCLT's dismissal of a Section 7 petition where the date of default was June 16, 2020, again coming within the COVID period window and thus within the moratorium period under Section 10A. So, the tribunal reiterated that once a default falls within the prohibited window, the direction is barred permanently and cannot be revived post suspension. However, there is some relief here. Recently, in Madras High Court, in a judgment as recent as 23rd of January 2025, in a case called Dharam Shri K. Patel versus Indian Bank, did say that if a fresh default occurs after this moratorium period which is prescribed in 10A, then application under 10A or application under Section 7 can be admitted and 10A can be ignored where there is a fresh default or where the default continues in some manner. Example, where this term loan was given for the emergency credit scheme, and today that emergency credit scheme was given to safeguard that company from a default, and the company is in default of those loans itself. So there again there is a possibility to distinguish from 10A and say that this is a continuing default. The default period is not within the COVID period.
Section 65 was inserted in IBC right from the inception to avoid and to kind of dismiss all those applications where the intent is not to resolve the corporate debtor from difficulties or from kind of any insolvency signs. Now, Section 7 applications are likely to be dismissed in case the adjudicating authority find that this has been filed with malicious intent or to abuse the insolvency process, and it has been filed in collusion with the corporate debtor or for any purpose other than the bona fide resolution of the insolvency of the company. So there are various judgments. So the one important judgment is that in the case of Expert Reality Professionals Private Limited versus Logix Infrastructure Private Limited, NCL80, held in this case on 17th January 2024, and it actually upheld a recall of a Section 7 admission after finding that the petition was filed by a related party in collusion with the corporate debtor. The debt claim was based on a fabricated MOU and lacked actual disbursement. The filing was held to be fraudulent under Section 65 aimed at misusing the CIRP process and frustrating other stakeholders. Penalties imposed by NCLT were in fact affirmed. In many cases, so this is something which the applications can be rejected by the NCLT. But there are many other applications which actually have been found as dismissed, being withdrawn. The applicant has the liberty to withdraw Section 7 applications at any time in case there is any settlement is reached or the default is cured. So therefore, the key points are they see like one, that the creditor who is applicant for Section 7 petition can withdraw the petition before it is admitted. And once it is admitted, then there is a complete process under Section 12 capital A of IBC and along with the relevant regulations that how it can be withdrawn even later. Yes, the other part that we actually can say, there was one case in which the Section 7 was in fact rejected. That was Vidarbha Industries Power Limited versus Axis Bank. In fact, the Supreme Court in that particular case took the advantage that there is a word written in Section 7 subsection 5 that the adjudicating authority may admit a Section 7 petition. In that case, the Honorable Supreme Court held that the corporate debtor was likely to receive some big amount from a legal dispute which was also pending. So one more important Supreme Court judgment in the case of Vidarbha Industries Power Limited versus Axis Bank, where Honorable Supreme Court, by taking the advantage of the word written may in Section 7 subsection 5 of IBC, in fact dismissed one Section 7 petition by saying that this company is not insolvent. This company can be, in fact, there was another dues which was pending before a government organization, and that there was an order in favor of Vidarbha Industries Power Limited, and that order was also in appeal with the Supreme Court. The Supreme Court in fact found that in case that particular order is disposed of by Supreme Court, then this company will get a huge amount of realization, and once that huge amount of realization will be given to that company, the company will be out of its insolvency. So that was the judgment which was in fact trigger enough that this lawmakers thought that there should not be any such discretion. Then in that case, there can be a kind of Pandora box that can be started. Everyone will say that my company is not insolvent. I have this difficulty. I am actually trying to realize money from this. I have an investor. All this can actually be part of the litigations. So therefore, IBC Amendment Bill 2025 have proposed that word may would be replaced with the word shall. So therefore, the adjudicating authority will not have any power to adjudicate the reasons of default. The only thing that the adjudicating authority will see, there was a debt and there is a default and the limitation.
Application is complete.
And application is complete. So therefore, when we see all this amendment bill in fact has focused on timeline. So in the coming days, once this amendment bill becomes the act, we can actually foresee that the Section 7 applications will be given priority. It will be admitted within reasonable time. The information utility, the record of default will be considered as mandatory. Therefore, if the debt is proved and information utility record of default is given and the application is complete and the AFA of the RP is given and there is no time barring, or Limitation Act applicability, then the application under Section 7 can be admitted in very, very short period. So that is what we are kind of visualizing. So therefore, today's episode, we in fact analyzed that what can be the reasons for rejection of Section 7 application. Our readers our viewers can actually look into all these reasons, and in case they can prepare their applications according to all these judicial pronouncements, I feel even today, even before this Amendment Act becomes bill, even today Section 7 applications can be admitted in very, very reasonable time. Thank you very much.